You walk into a courtroom thinking it's about facts, evidence, right versus wrong. But what if, before a single word is spoken, 12 silent assumptions have already decided your position? Not proven, not tested, just accepted. And if you don't challenge them correctly, they don't stay as assumptions. They become reality inside of that system. Most men and women are taught that law is built on fairness, that there's a neutral process waiting to hear both sides. But when you look closer, what you actually find is something operating underneath the surface. Presumptions. And those presumptions, they don't ask for your permission. They don't announce themselves. They sit quietly in the background, shaping how everything you do is interpreted. So it's not really a matter of what happened in your case, it's what was assumed about you before you even arrived. So let's start with the first, the presumption of guilt. You've heard the phrase, innocent until proven guilty, but step into the process and watch how quickly that flips in practice. You're questioned as if something has already gone wrong. You're positioned as somebody who needs to explain themselves. And that subtle shift puts you on the back foot straight away. Because now you're not standing in neutrality. You're responding to an invisible accusation. And if you don't recognise that, then you play into that. Second presumption is the presumption of authority. That those inside the system, the judges, the prosecutors, the officials, all hold superior positions, not just in the roles that they play, but in their standing. So when you speak, you're not speaking from across the table, you're speaking upwards. And that imbalance affects how everything you say is received, interpreted, and recorded. And so essentially you are shouting upwards, speaking upwards to a structure that has already placed you beneath them. And once that perception of authority is accepted, everything else changes. Their words are recorded as guidance. Yours can be treated as reaction, confusion, emotion, or resistance. The third presumption is the presumption of lack of knowledge. This is where the system assumes that you don't understand its language, its terminology, its procedures, or the meaning of what is taking place. And for most people, that assumption will partly fit, because the language is specialised on purpose, as you know. And what do we call that specialised language? Comment below. Words appear familiar, but function differently inside the process. Terms that sound ordinary carry procedural weight. Silence means something. Response means something. Timing means something. And if it's assumed you lack knowledge, then the system has room to define the meaning of your conduct for you. Your words can be translated for the record. Your position can be narrowed. Your intent can be interpreted through their framework instead of your own. The fourth presumption is the presumption of ignorance. This goes further than the lack of knowledge. The lack of knowledge means that you may not understand the language. Ignorance means that the system assumes that you just haven't got a clue as to what's happening to you and done to you, that you don't know what role you've been placed into, that you don't know what assumptions have already been made, that you don't know what rights you believe you have versus what position the system is actually assigning to you. And once the ignorance is presumed, your silence can be treated as acceptance. Your failure to object can be treated as understanding. Your participation can be taken as informed engagement. So the presumption of ignorance is dangerous because it allows the system to move forward while treating your lack of challenge as though it means nothing important is being contested. The fifth presumption is the presumption of consent. This is one of the most important, because once consent has been assumed, the whole framework starts to tighten around you like a boa constrictor. You may think, I never agreed to this. I never signed that. I never accepted their authority. The system may not require that kind of explicit agreement you imagine it should. Instead, they can treat conduct as consent. You answered the letter, you attended the hearing, you responded to the notice, you entered the building, you used their forms, you engaged in the process. And as a side note, which you are we talking about? That whole behaviour can be read as consent. Agreement. Agreement to jurisdiction. Agreement to procedure. Agreement to the rules and engagement. Agreement to have the matter handled inside their framework. So even where no clear spoken consent exists, presumption of consent can be built from your conduct alone. The sixth presumption is the presumption of incorporation. Once consent is assumed, incorporation follows closely behind. This is the point where you are no longer viewed as someone merely encountering the system. You are treated as having been brought into it, absorbed by it, bound by its language, bound by its internal logic. At this stage, you are no longer standing outside challenging what is. You're being processed inside of it according to what it says it is. And that's how they get you. Because once you're incorporated, every attempt you make to resist is filtered through that same structure that has already enclosed you. And now pause there, because that's the first major turning point. Once guilt is assumed, authority is elevated, knowledge is dismissed, ignorance is presumed, consent is implied, and incorporation is now in place. You are no longer approaching a neutral arena. You're already inside a managed position. The seventh presumption is the presumption of government authority. This is the assumption that the authority of state, or those acting under it, is inherently lawful, superior, and legitimate from the outset. Not something to be proved, not something to be established first, but something already standing before you even say a word. So if you object, you are not simply disagreeing with claim, you are seen as resisting authority itself, and that alters then how the resistance is framed. What might be a legitimate challenge in your eyes can be recorded as obstruction, non-cooperation, or refusal to comply. Because once government authority is presumed supreme, your position can no longer be compared on equal terms. It is measured against an authority already being treated as valid. The eighth presumption is the presumption of validity. This means that document processes, orders, applications, certificates, administrative steps, and procedural acts are all treated as valid, unless and until you disprove them. That is a major reversal, because that means that the burden quietly moves onto you. A notice is presumed as proper, a claim is presumed regular, a filing is presumed as effective, process is presumed as lawful, and if anything is defective, irregular, misleading or false, you are the one expected to raise it, identify it, and prove it. So the presumption of validity does not begin with proof of correctness. It begins with correctness being assumed. The ninth presumption is the presumption of infraction. This is the idea that some breach, some non-compliance, some violation has already taken place. Maybe not fully articulated yet, maybe not fully proven yet, but hanging in the air from the beginning. And that atmosphere matters, because it means that you're not entering a clean inquiry where all possibilities remain open. You're entering a framework that already leans toward the expectation that the rule was broken, that something is amiss, that the fault exists somewhere. So even before the details are established, the process can already begin to be tilted toward locating and conforming the infraction it assumes is there. The 10th presumption is the presumption of collaboration. And this one expands the net, because once a position is assigned to you, those connected to you can be viewed through the same lens. Friends, family, associates, colleagues, supporters, witnesses, people helping you, people standing beside you. Their involvement can be coloured, not necessarily by evidence, but by association. And that creates pressure, because the system no longer only affects the name individual, it reaches outwards. It can discourage people from helping. It can make support appear risky. It can isolate the person at the centre of the matter. So the presumption of collaboration strengthens control, not by proving a conspiracy, but by allowing association itself to cast suspicion outward. The 11th presumption is the presumption of representation. This is where most people relax, because they assume that once a representative is involved, everything is now protected. The person speaking for them is competent, aligned, diligent, acting fully in their interest, and testing every assumption that needs to be tested. That too is a presumption, because representation does not automatically mean loyalty to your exact position. It does not automatically mean that every hidden assumption will be exposed. It does not automatically mean that the strategy being used protects you from all the other deeper framework already operating around the case. And if that assumption fails, the system doesn't usually absorb the consequences of that failure. You do. So the presumption of representation can be one of the most dangerous, precisely because it feels safe. Because once a person believes somebody else is handling it, they often stop examining the structure for themselves. And that's exactly where the critical things can pass unchallenged. The 12th presumption is the presumption of impunity. This is the quiet assumption that those operating within authority, especially institutional authority, are unlikely to face any consequence in the same way that you would. Look around. When did we ever see anyone in power being held responsible, accountable? Never. How many Epstein file named people have seen jail time? And so very much like that, in situations like legal things, abuse can be overlooked. Misconduct may be protected by process, by hierarchy, by professional courtesy, or by simple reluctance to challenge insiders. In other words, accountability isn't very often applied evenly, and if impunity is effectively presumed, then that imbalance becomes extreme, because one side enters under scrutiny while the other side enters with protection built all around it. That is the legal framework. And before you've even ever opened your mouth, that framework may already be shaping how you are seen, how you are heard, and how the process moves around you. Beyond those 12 presumptions, there's another layer that most people don't see, and this is where behaviour becomes critical. Only members of the bar can formally argue in court. When a man or woman walks in and starts arguing facts directly, thinking that they're defending themselves, they may unknowingly enter a position of dishonour within that system. And once dishonour can be attached, it can be used to justify jurisdiction, used to reinforce authority, used to keep the process moving, used to avoid the underlying challenge by redirecting attention to conduct inside of the courtroom itself. So even where somebody tries to challenge the presumptions, the very form of that challenge end up feeding process they meant to resist. Now think about that carefully. A man or woman can walk in believing they're doing exactly what they should do, speaking clearly, defending their position, presenting facts, objecting strongly, trying to expose what's wrong, and yet the way that it's done, the form, the posture, the delivery, can actually strengthen the system's hold over them. That's the trap. which is why some say the real work has to happen before you even get to the courtroom. The pen is mightier than the sword. Through notices, through written position, through process, through conditional acceptance, through carefully framed responses. Because once physical attendance happens, many of those presumptions are no longer dormant. They are active, already standing, already influencing interpretation. There's an important boundary here. This whole framework centres around what are described as victimless matters. If there's a clear harm, clear loss, a flesh and blood victim, then the position changes, because that introduces a different foundation entirely, and that distinction has to be made clear. And so I'll close with this. Everything that you've just heard sits on a much larger claim, that what presents itself in the public system is in fact operating through private mechanisms, through internal guild structures, through specialised language, through rules and customs, not openly explained to those entering into them, that what appears to be a neutral public arena may actually function as a controlled environment, governed by those trained within it, aligned to its own internal logic, protective of its own continuity. And if that's even partially true, then the experience most men and women have with law needs to be re-examined from the ground up, because it stops being about what's right and wrong, and it becomes about position, standing, capacity, presumption, and the differences between what's being proven and what's simply being allowed to stand. Anyway, this video has taken me far longer than I'd hoped, so I hope you've made it to the end. I hope you've enjoyed it. If you have enjoyed it, please hype it, like it, share it, subscribe, hit the notification bell, make sure you click for all, because only a small smidgen actually watch. So thank you for watching if you have, and yes, all the best. I shall see you in the next video. Let me know what you think in the comments, and bye for now.